Imagine going to the dentist, sitting in that chair, letting them poke around in your mouth, trusting them completely, and then finding out months later that your face, your smile, your most embarrassing dental moments are plastered all over Instagram without your knowledge, without your permission, and without a single word of warning. Not on one page, not on 2 pages, on 3 separate Instagram accounts. And when you ask them to take it down, silence. Complete and total silence, except for the emails reminding you to come back in for more dental work. That is exactly what happened to one man in Bucks County, Pennsylvania, and his wife's story has sparked a fascinating and deeply important legal conversation about patient rights, medical privacy, and what dentists, and really any healthcare provider, are actually allowed to do with your photos. Stay with me, because this one gets complicated, it gets infuriating, and it has lessons that every single person who has ever sat in a medical or dental chair needs to hear. So let's set the scene. A man in Pennsylvania needed dental work done. Nothing unusual there. Millions of people get dental procedures every year. Fillings, crowns, cosmetic work, you name it. When he arrived at the practice, staff took photographs of him. Now this is also not unusual. Dental offices routinely photograph patients' teeth before and after procedures. It helps them track progress, document their work, and keep a visual record alongside the rest of your chart. When he asked what the photos were for, he was told clearly and simply, "They are for your records, not for marketing, not for social media, for his records." He had no reason to doubt that. Why would he? He was a patient in a professional medical environment, and a staff member had just given him a direct answer. So he went through his procedure, did his follow-up appointments, and moved on with his life. He's not on social media at all. He has no Instagram, no Facebook, no TikTok, none of it. So even if something had gone up online, he would have had absolutely no way of knowing. And that brings us to the moment everything changed. At one of his follow-up appointments, a staff member at the dental office made a comment that stopped him cold. She said she recognized him because he was, and I'm quoting here, Instagram famous. He was confused. Understandably so. He doesn't have Instagram. He's not a public figure. He's just a regular guy from Bucks County who needed some dental work. The staff member clarified, he was on the dentist's Instagram page. He went home that day and asked his daughter if he could use her account to search the practice. What he found was worse than he expected. The dentist had posted before and after photos of his dental work, and not just close-up shots of his teeth. Those might have been uncomfortable enough on their own, but full-face photographs. His actual face, recognizable to anyone who knows him. Before photos showing his teeth in what his wife described as an embarrassingly bad condition, and after photos showing the results of the work. The kind of content that dental practices use all the time to advertise their services and attract new patients. But here's the part that makes this particularly egregious. Those photos weren't just on one account. They had been tagged and shared across 3 separate Instagram pages. The main practice account, the personal account of the dentist, and the account of the co-owner of the practice. 3 accounts, 3 separate audiences. 3 separate instances of using this man's image and medical information without his consent. His wife went back through every single online form he had signed when he became a patient. Every single one. She searched specifically for any language at all, that would have authorized the use of his photographs for marketing, advertising, or social media. She found nothing. Not a clause, not a sentence, not even a vague reference to photos being used for promotional purposes. What she did find was a signed HIPAA form, a form explicitly stating that the practice would not disclose his personal information. Now, his wife emailed the dental office twice on his behalf, asking them to remove the posts. Both emails were ignored. But here's the detail that really reveals the character of this situation. While they were ignoring those requests, the office did email him, just not about the photos. They emailed him to recommend additional dental work. They had no problem reaching out when there was money involved. When it came to respecting his privacy and his explicit requests, nothing. So let's break down what's actually happening here legally, because this situation involves several intersecting areas of law. First, let's talk about HIPAA. The Health Insurance Portability and Accountability Act is the federal law that governs how healthcare providers handle patient information. Photographs taken in a clinical setting, especially photographs that document a patient's medical condition, like the state of someone's teeth before a procedure, are considered protected health information under HIPAA. Using those photographs for marketing purposes without explicit written authorization is a HIPAA violation. And the key word there is written. HIPAA has very specific requirements about marketing authorizations. Verbal consent is not enough. A general intake form is not enough. There must be a clear, specific, written authorization that tells the patient exactly how their information or images will be used, and that authorization must be voluntary and informed. If the patient was told the photos were for records only, that is the opposite of informed consent for social media use. HIPAA complaints can be filed with the Office for Civil Rights, which is part of the U.S. Department of Health and Human Services. Violations can result in significant fines for the practice. In cases where a covered entity knowingly misuses protected health information, those fines can reach into the tens of thousands of dollars per violation. But HIPAA isn't the only issue here. Pennsylvania, like most states, recognizes what's called the right of publicity and the right of privacy. Using someone's likeness, their face, their image, for commercial purposes without their consent can constitute what's known as misappropriation of likeness. This is a civil cause of action, meaning the person whose image was used without consent can potentially sue for damages. The fact that this was used for commercial gain, attracting patients to a dental practice, strengthens that argument considerably. There's also a potential claim for invasion of privacy, specifically the public disclosure of private facts. Posting before photos of someone's teeth in a condition they find embarrassing to a public social media audience without their consent hits several of the elements of that tort. The information disclosed was private. The disclosure would be highly offensive to a reasonable person. And it was not a matter of legitimate public concern. The type of attorney this family should be looking for is either a healthcare attorney with experience in HIPAA violations, a privacy attorney, or a personal injury attorney who handles civil rights and privacy cases. Many attorneys who deal with medical privacy violations work on contingency, meaning they only get paid if you win, which makes it more accessible for people who aren't sure they can afford legal fees up front. Now here's what every single person watching this needs to take away from this story. Before you let any medical or dental professional take photographs of you, your face, your body, your procedures, ask them directly and specifically what those photos will be used for. Get the answer in writing if you can. When you're signing intake forms, read them. I know that sounds obvious, but most of us scroll through and sign without reading a word. Look specifically for any language about photography, marketing, social media, or the use of your image. If you see language that you don't agree with, you have the right to cross it out, ask for it to be removed, or decline to sign that particular clause. You also have the right to refuse photographs entirely in many cases, especially for non-clinical purposes. If you discover that a healthcare provider has used your image without consent, do not just let it go. Document everything. Screenshot the posts immediately because they could be taken down and you'll want evidence. Send a formal written request, not just an email, but a certified letter demanding removal. Then file a complaint with the Office for Civil Rights at the HHS website. It's free, it's straightforward, and it puts the federal government on notice. And consult with a privacy or healthcare attorney to understand your civil options. Healthcare providers have enormous power in the patient relationship. You are often vulnerable, often in pain, and you are trusting them with your body. That trust should be sacred. Using someone's medical images to grow a social media following, without consent, without disclosure, and in direct defiance of the patient's requests, is a betrayal of that trust, and in many cases, a violation of the law. If this has happened to you or someone you know, if a doctor, dentist, or any healthcare provider has used your image or your medical information without your explicit consent, you have options, and you have rights. Start by documenting everything you can find. Then reach out to a qualified attorney in your state to understand the full scope of what you can do. You do not have to accept being someone's marketing content without your permission. And if you found this video helpful, if it opened your eyes to rights you didn't know you had, please subscribe to this channel. We cover real legal situations that affect real people, and we break them down so you understand exactly what the law says and what you can do about it. Hit that subscribe button, share this with someone who needs to hear it, and we'll see you in the next one.